the basic fact setup of the case, as I recall from reading the opinion, is that there were several contracts, one of which had an arbitration provision, others that did not. And I think there was some jockeying in the pleadings. I think maybe some of the claims on some of the contracts that had arbitration provisions were dismissed or something. And then, so the question was, do the claims on these other contracts get arbitrated or not? And the trial court said, well, we're going to leave that to the AAA arbitrator, because the arbitration provision says that, or the AAA rules say that the arbitrator gets to decide arbitrability. And you got the second district to say, no, that's not the case here.
Yeah, it's a really confusing area of the law. It's even if you have a reference to AAA rules, they consider that to be clear and convincing evidence of a delegation to the arbitrator. And as I'm sure you guys know, once they say it goes delegated to the arbitrator decides almost every dispute that could possibly come up with the contract. And so we were actually delighted to see this Moritz case from from the first district, which at least there was one court out there that had done some, treated the initial issue as, is there a contract with an arbitration agreement at issue first? And part of it was figuring out the wording, because normally you'd say, is it arbitrable? But, the wording has been, if it's arbitrability, it goes to the arbitrator to decide. So, we changed it to threshold question. And,
yeah,
we really focused on the statutes, which say the burden is on the party seeking arbitration to show that there is a contract and an arbitration provision at issue to begin with. And so we said the delegation to the arbitrator skips that step, and it just goes straight to the delegation. And that particularly in our case, where there's multiple contracts, just like in the Moritz case, that there has to be a different rule when your argument is that, so in our case, there were 7 loan documents, none of which had arbitration agreements, most of which had specific venue requirements, jurisdictions. And then the arbitration agreement itself said was in one separate contract entered into 7 weeks later. And it said it was a broad arbitration agreement, but it said it was for this agreement. And it was entered into after the 7 loan documents, but it didn't reference the loan documents. So we were able to convince the court that those contracts and the complaint, after we dismissed the 2 claims that involved the later agreement with the arbitration agreement, the complaint only addressed those first 7 loan contracts. And so we convinced the court that first the trial court has to decide whether this dispute involves those 7 loan contracts or the 8th contract. And then at that point, if it did involve the 8th contract with an arbitration agreement, it could get delegated out to the arbitrator. Yeah. But in this case, they agreed with us that the 7 loan documents were not at issue. And so the trial court should have denied the motion to compel.
Got it. So this was somewhat fact-driven based on the fact that there was multiple contracts. Is there a broader holding that, or broader lesson from the Banc of California case that our listeners should take away when they see contracts with arbitration provisions that invoke the AAA rules?
Yeah, I think, some of that came out of the oral argument where the justices, Division 7 is, all the justices are amazing, but Division 7, everyone had questions. All 3 of the justices were really pushing both sides to put out the broader parts of the rule that they wanted to create. And the other side suggested that if tenants signed a lease with a landlord, and then on the way out of the building, and then something, or not a lease, some kind of contract with the landlord, and then are leaving the building and they're, a container falls on their head or something. They said, is that injury, are you saying that would be connected to this contract, even though in time it is, but it's clearly not what's in dispute. And so I think the court was was suggesting that there are areas, especially if you have torts, maybe separate from your contract claims, where it should be separately evaluated.
Yeah, when I read this case, and as we started talking about it, I was reminded of the Brad Pitt and Angelina Jolie case, and it's a little bit of a different circumstance because that dealt with a pro tem judge. But I thought it was a little. What made me think about it is this question of who decides the threshold question of whether the dispute gets arbitrated. I think that a court has got to make that call, not an arbitrator or a private judge. And I think by delegating that to an arbitrator, that seems to me no different from delegating it to a private judge. And I remember the forceful dissent, was it dissent or concurrence? I can't recall, by Justice Siegel in the Angelina Jolie case, where he quoted the 1992 Judicial Council report stating, quote, "Privately compensated judges pro tempore is illegal and pernicious. We are not for sale, nor is the product of our labor." And I thought that the idea of delegating the threshold question of arbitrability, seemed to kind of get a little bit too close to that line.
Yeah, I think that's a good point. And, one of the problems is the U.S. Supreme Court case Shine was, pretty clear that if it's got a delegation provision, it's going to the arbitrator and they decide everything. And that was a huge hurdle for us to get around. Margaret really identified that before we went into argument as something she was going to get pinned down on isn't the U.S. Supreme Court saying, everything, no matter what, goes to the arbitrator first with the arbitrability question. So we were happy to carve out our little exception that we were able to get. But also I do think, I don't know if the federal courts are doing it or not, but they're saying that it's a clear delegation just by referencing the rules. We include AAA rules, or we agree to use jams, and that means you are clearly, that's clear evidence that you want to delegate everything to an arbitrator. And I think that California courts should definitely take another look at that.
Yeah, I agree. This whole notion of allowing a system of private judging or arbitrations and the money that's involved in that system, giving them the question to be decided when they have such a huge incentive to grow their caseload, and the setting up of two systems of justice where, the traditional public model where people have to wait years, or the private model where things are done quietly, confidentially, and if you have enough money to afford to pay the fees. I really find it distasteful. I read today from Ben Schott's blog that presiding Justice Anthony Klein of the First District is retiring. And he was quoted when he was asked about his retirement about, is he going to go to jams or go to AAA? And he politely said, no, he's going to do some social justice work, and said, the whole notion to me of private judging is an oxymoron. The increasing number of disputes that are being decided in private arbitration behind closed doors is undermining public justice. I don't think people understand the significance of having independent courts. And I'm sad he's leaving the court. I think he was a voice that is needed.
Yeah, I think arbitration is really not understood by the public. I completely agree.
Yeah, a warning note for our listeners: 3 appellate attorneys are hostile to arbitration.